Okay, welcome to this Refugee Law Initiative Conference panel session on asylum in late sovereign world, the application of refugee law in overseas and dependent territories. I hope you are well and ready for attending one of the three last panels of this stimulating conference. My name is Silvia Morgades Gil, and I am Serra Hunter Associate Professor of International Public Law at Universitat Pompeu Fabra in Barcelona, and I also are a research affiliate at RLI. I am very honored to chair this panel, which seeks to explore the challenges posed by the applicability of international refugee law in non-self-governing territories. Current developments suggest that overseas and dependent territories may play an increasing role in refugee protection, and that there may be gaps in such protection. Since some years ago, we face a certain hyper-territorialization of the access to rights. And for this reason, it's so relevant to analyze if sovereignty is being in some way diminished when international protection is at the stake in some places. Our speakers today will start us off by presenting key perspectives on four quite different components of this issue, after which we will open up for a broader discussion. Questions and comments from other participants. Full details of the panels and presenters that may cap this panel can be found in your conference program. Each of the four speakers on this panel will have 10 minutes for their presentation, which I have been asked to enforce strictly. After the speakers have finished their presentations, there will be time for them to discuss and reflect on your questions and comments. Please remember to keep your microphones on mute and your videos off unless you are a presenter. The session is being recorded and will be posted on the RLI website as a podcast. If you do not wish to appear on the podcast, please leave the session now. We are going to start with Professor Thomas Hamilton Hansen. Thomas is professor with special responsibilities in migration and refugee law at the University of Copenhagen. In addition, he is honorary professor at Aarhus University. He is author of recent publications on extraterritorial human rights obligations and on the regulation of asylum in the Arctic. Thank you very much, Thomas. You have the floor.
Thank you very much for the kind introduction and to the organizers for allowing me to speak here today. So this panel is, in a sense, a kind of inverse case to the kind of external asylum processing and efforts of kind of externalizing refugee protection, which was the theme of this conference first declaration. And in this panel, we want to look at territorial bifurcations of asylum and refugee regulation. This is, of course, an old horse in some context. We've all previously talked and written about excision of territory, such as airports or coastal lines in both Europe, Australia, and elsewhere. But in a number of situations, often related to overseas, autonomous, or dependent territories, states may also seek to exploit pre-existing territorial structures in order to realize political or economic goals. We know this well from international political sociology, where these type of offshoring arrangements, such as, for instance, the US Virgin Islands or Guantanamo in relation to the US, have been used for exactly these type of purposes. But so far, there's been somewhat less attention to these types of situations among refugee law scholars, and this is what we want to focus on today. The core argument in my initial paper is that the underlying rationale of externalization, which is often said to be an effort to realize what can be termed as protection light, meaning the presence of formal protection structures, but with a lower certainty, scope, and or level of rights, may also be realized within a state's own sovereign territory. And secondly, that while existence of territory like airports or coastal zones have historically often been dismissed by international courts as quote unquote legal fictions, when such models are based on pre-existing what we call late sovereign constellations as related to these type of overseas autonomous or dependent territories, international legal bodies tend to take a much more reticent stand, and international law may even itself be argued to support a displacement of national legal protections. So what emerges in these type of situations is thus a twist on Agamben's famous conception of the refugee as an archetype of rightlessness. In my own work, I refer to this as bare international life, in that international rights become unmoored from the underlying national protection systems. Now, the presentation I'm making here is based on a recent article in the Nordic Journal of International Law, co-authored with a great colleague of mine, Sune Klinge, which explores these dynamics in the Arctic region, more specifically as related to Greenland and Svalbard. I'll be talking only about Greenland today, but I'll encourage anyone interested in these types of dynamics and issues to read the Svalbard analysis as well, which in some respects represents an even more extreme illustration of this type of argument. I'll allow myself to start by becoming a little bit personal. What you see here is a picture of Ivan Dumanov. He was a refugee from Ukraine who fled following the Crimea invasion and applied for asylum in Greenland in 2015. His rationale was that he was fleeing at a time where all of Europe was succumbed by talks of Syrian refugee crisis, and that it was maybe better to be the first asylum applicant in a territory as opposed to number 1,000,001. And this is a quote from himself. However, things didn't exactly go as planned, however. So I got involved because his case stalled and got stuck for years in a legal struggle between the Danish and Greenland authorities. And because Ivan was the first person ever to be granted asylum in Greenland, it raised a number of quite principled issues, which became the backdrop for the article that I just referred to. Now, Greenland is an autonomous territory, which has self-government, which was established in 2009, formerly part of the Danish realm. And according to the Self-Government Act, the Greenlandic government alone decides whether and when to take over competence for a given policy area. But for some areas which haven't already been taken over by the Greenland self-government, including asylum and immigration, regulation is instead enacted through old, actually colonial legal instruments, in particular royal decrees. And a royal decree is an instrument that enables Danish legislation to be enacted and given effect in Greenland with possible adjustments that the local context may require. And for the Danish Aliens Act, which is the primary instrument governing asylum and refugees, this was done in the year 2001. In anticipation of more foreigners arriving in Greenland as part of deals with foreign mining companies keen to explore mineral resources. So in itself part of the Greenland independence process. And the royal decree, if given effect to the Danish Aliens Act, establishes Greenland as an independent travel, visa, and immigration area. This also applies for refugees. Any successful asylum applicant will thus get a separate residence permit, limiting his or her stay to the Greenland territory. However, due to the lack of local asylum capacity, the asylum procedure is organized in such a way that in practice, it's being handled by the Danish authorities. So we know this as well in Europe from some small sovereign territories that you have sort of lending judicial powers. And for this kind of arrangement, it will be the Danish authorities, the immigration service, that handles the application in the first instance. And then for any appeals, it goes to a special refugee appeals board for Greenland, but which is in practice also composed of members from the Danish refugee appeals board, but with an additional representative from the Greenland government. It also means that upon launching an asylum application in Greenland, which Ivan did, any applicant is physically transferred to the Danish territory for the duration of this process. Now, one of the remarkable effects of looking into this type of regulation is that the use of royal decrees basically creates a form of time capsule effect. Basically, initiating law through royal decree means that many, or indeed most, subsequent legal amendments do not automatically take effect in Greenland. So when the Danish asylum or immigration laws are updated, it doesn't automatically mean that these changes are carried over in Greenland. In practice, it means that the asylum procedure and also the substantive rules on asylum are basically locked in as they were in Danish legislation in 2001. That's not necessarily a bad thing for anyone well-versed about the direction and trajectory of Danish asylum and migration regulation. It basically means that the 100+ restrictions enacted in regard to the Danish Aliens Act for the last 21 years, such as the rules creating a new temporary protection status, rules restricting access to family unification, rules enabling the cessation of protection permits for certain types of Syrian refugees, and indeed the legislation enabling third country asylum processing, none of that actually applies in Greenland. It also means that the Refugee Appeals Board for Greenland is composed as it was in Denmark in 2001, including a more, you can say, balanced composition of the members with NGO representatives. And it means that asylum applications have to be measured in accordance with old Danish law and the so-called de facto standard, which was a more liberal national standard, as you would be well aware of, also applied in many other European countries, that is more generous than the current Danish rules, and in some respects also more generous than the common EU asylum rules, especially for persons fleeing for generalized conflict, that are generally entitled to a more generous standard of protection. So this is sort of the first major point here, that for a country like Denmark, which has really taken a U-turn in terms of asylum law over the last few decades, this almost creates a sort of natural experiment where placing the current Danish rules in a very stark relief as opposed to what it could have been if we had had this sort of time capsule effect. And of course, none of this is detrimental to an asylum seeker's position. So far, so good. It's very remarkable, but it doesn't raise any specific problems from an international law perspective. The problem, however, emerges following positive assessment, which is what happened to Ivan. Because in Greenland, there is no adjoining refugee integration law framework. So they enacted the asylum and immigration legislation, but they did not enact the Danish integration law. And indeed, this particular area of competence is sort of stuck somewhere in the middle because it formally resides under the social regulation area, which has been taken over by Greenland. So only Greenland's government itself would be able to do so. However, due to arrangement under the Self-Government Act, it means that the money to cover any integration cost is not transferred from Denmark to Greenland. It's one of the major changes in the self-government rule. And in practice, it means that refugees are only entitled, if they are getting refugee status in Greenland, as Ivan did, to the most limited forms of public benefits. There's no system for education of refugee children. In practice, there's no capacity to support language training from any other countries than Danish or English into Greenlandic. And in practice, there is no available housing. Indeed, there's a 20-year-long waiting list for access to public housing in most parts of Greenland. And for Ivan, when he finally decided, after much struggle between the Danish and the Greenlandic government, where Greenland said, well, we have no capacity to ensure his integration, Ivan ultimately decided to buy a plane ticket himself and arrived in Nuuk. There was absolutely no reception. He was given, after some time, some food tickets. He did not have any kind of referral to housing in Greenland for the initial period of his stay. Fortunately, he had networks that enabled some kind of funding for temporary housing. Now, that really illustrates, I think, the sort of multi-directional effects of this type of regulation, that on one hand, you may actually have more generous asylum rules, but they're backed up by a much more restrictive regime surrounding refugee rights upon recognition. And this is particularly stark in this context because the general social provisions, general rules on social welfare, are at a much lower level for Greenlanders as well, and for anyone residing in Greenland, than they are in Denmark. So Ivan's hunch in that sense did not get confirmed. However, what did happen, and I'll be turning now to sort of a little bit of an aftermath story, was that his hunch that it's better to be number one than number 1 million was indeed correct, in the sense that ultimately local Greenlandic politicians took an interest in his case. And through networks, a job in the municipality of Nuuk, the main city of Greenland, was created. With the job came access to an apartment. And for a number of years, Ivan actually really thrived. He was a highly educated single male. He had a university degree. He was cherished in Greenland and became highly integrated, learned a lot of the language, had a lot of friends, a girlfriend, etc. And as you'll see here in this picture, took up both sailing, fishing, and hunting. Now, that's of course a success story, but it's a success story based on the sheer willingness of individuals to help this person out. On the first day of Ivan's job, he was greeted by his boss to his new colleagues with the words, "This is Ivan. Ivan is Greenland's first refugee, and we hope the last." Because the situation would have looked very, very different if this had been a larger group of people, or indeed a different type of maybe a refugee family with many children, requiring more in terms of integration measures. And as a twist, again, on this particular and very, for me, quite personal story, some months ago in March, Ivan contacted me again. Being from Ukraine, he now had the trouble that he wanted to go back, and being in a separate travel area couldn't actually secure legal access to leave Greenland in order to go back, because he wanted to join the fight in Ukraine following the Russian invasion. He ultimately succeeded in doing that, not by entirely lawful manners, and became part of the Ukrainian resistance. And about a month ago, I received the very sad and tragic news that Ivan had been shot at the Eastern Front. And so ends that story of Greenland's first refugee. And it is a story that meant that the local Greenlandic government and the municipality of Nuuk actually very much mourned his departure, and all official flags were at half-mast on the day of the announcement of his death. Now, for the principal issues raised by this story, I will come back in the discussion, as I think much of that will also be touched by my fellow presenters. Thank you very much for your time.
Okay, thank you. Thank you very much, Thomas, for your talk, which combines legal analysis with emotion that the history is entailing. Well, we turn now to our second speaker, and we move to the south of Europe. We have Professor Maria Teresa Gilbazo, who is associate professor at the University of Navarra in Spain. She will be presenting a paper on the EU's external border with Gibraltar and refugee protection. She has recently published also articles on Article 4, prohibition of torture and inhuman treatment, a commentary of the EU Charter, and also a chapter that is the right to asylum in the Oxford Handbook of International Refugee. Thank you, Maria Teresa. You have the floor. Teresa, we are not able to hear you.
Okay, I think I am on mute now. So thank you very much, Sylvia, and thank you very much to my fellow panelists in this session, as well as to everyone who's interested in this topic. The research that Thomas has just presented is a perfect example of the continuing relevance of relations between territorial entities and their specific impact on refugee protection. The papers in this panel present the analysis of legal and policy developments under different arrangements between states and what once were non-self-governing territories, so colonial territories, and have now different legal statuses. Some remain linked to their former administering powers by international arrangements of constitutional law, such as Greenland, which you just heard about, Curaçao, Aruba, and Bonaire in relation to the Netherlands, while others have acquired independence as states, such as Rwanda, a former colony of Belgium, as part of a mandate from the League of Nations, and later under the United Nations. And one of the territories examined in this session, Gibraltar, was and still remains a non-self-governing territory under the former administration of the UK. And it is the only colonial territory still existing in Europe with that status as non-self-governing territory. This paper will present the colonial clause in Article 40 of the UN Refugee Convention and will then explore its continuing relevance. In particular, it will analyze this case of Gibraltar. As a matter of British constitutional law, Gibraltar is a British overseas territory, but as a matter of international law, Gibraltar is a non-self-governing territory under British administration in accordance with Chapter 11 of the Charter of the United Nations. Gibraltar was part of the European Union's territory until the withdrawal of the UK from the EU, and so now it constitutes an external EU border, land and sea borders. Furthermore, it is a territory for which an international dispute exists between the UK and Spain, the bordering EU member state. And this poses a number of legal challenges as a matter of international and EU law, including on asylum matters that are currently under negotiations between the European Union and the UK. So what we're looking at here is the implications of that new status of Gibraltar as a non-European Union territory anymore when it comes to refugee protection under international and EU law. The 1951 Convention provided for its application to non-self-governing territories in Article 40. So I have looked at this matter in depth at the Oxford University Press commentary on the UN Refugee Convention, whose first edition was published in 2011, and the second edition is in the course of being published at the moment and should come out, eventually this year or next year. So what I'm going to present here is just an overview of this provision to serve as background for the analysis of the specific territories considered in this panel. So Article 40 of the UN Refugee Convention says that at the time of becoming a party to the UN Refugee Convention, any state may declare that this convention shall extend to all or any of the territories for the international relations of which it is responsible. When the administering power does not extend the application of Article 40 to its colonial territories at that time of becoming a party itself, paragraph 3 of Article 40 encourages those states to consider the possibility of taking the necessary steps in order to extend the application of this convention to such territories. Now, the so-called colonial clause was known to the practice of states in international treaties within the League of Nations, but it did raise controversy in the United Nations era because of its political nature. The controversy as to its inclusion in the 1951 Convention held a prominent place in discussions during its drafting history. Several states entered declarations to Article 40, including notifications of territorial applications. So it is not surprise, perhaps, to know that Denmark, the Netherlands, and the UK at that time entered declarations of notification of territorial application in relation to the territories, some of the territories that they were responsible of. And they likewise extended some of their reservations to those territories as well. In particular, the UK introduced reservations and declarations when it comes to the application of the Refugee Convention to its colonial territories in relation to Article 3, non-discrimination, Article 8, exception from exceptional measures, Article 17, paragraph 2, wage earning employment, Article 24, paragraph 1 and paragraph 2, labor legislation and social security, as well as Article 25, paragraphs 1 and 2, administrative assistance. So even if the UK extended the application of the Refugee Convention, it did so with a number of significant reservations when it comes to refugee protection in those territories for which it was responsible. So Article 40 was the object of discussions during the drafting process, and these discussions were informed by developments elsewhere, and that's quite interesting because there was at the time a specific report prepared by the legal department at the request of UNHCR that contained all federal and colonial clauses adopted by all UN organs, as well as summaries of the discussions. Therefore, the inclusion of a colonial clause in the UN Refugee Convention was done after a lot of discussion, a lot of divergent views, and with a very conscious matter from states that they still wanted to include that clause there for the purposes of expanding the application of a treaty that they consider was relevant in terms of protection. So as I was saying earlier on, one of such non-self-governing territories is Gibraltar, which also happens to be at the external borders of the European Union and is under British administration in accordance with the United Nations. The UK has never made a declaration in relation to Article 40 to this territory, even if it has done a number of declarations in relation to several of its other colonial territories. And therefore, the UN Refugee Convention does not apply to Gibraltar. This means in practice that as a matter of international law, the UK has no international legal obligation under this treaty when it comes to events taking place in the territory of Gibraltar. Now, we can raise the issue of jurisdiction, but in the 10 minutes that we have allocated, I will not be considering that. So what exactly constitutes the territory of Gibraltar is furthermore contentious, as the territorial delimitations established by the 1713 Treaty of Utrecht and the actual land currently occupied by Gibraltar, notably its port and airport, do not coincide. When it comes to EU law, Gibraltar was part of the European Union until 2020, and as such, the EU treaties applied to Gibraltar, including the Charter of Fundamental Rights of the European Union, and specifically the right to asylum in Article 18, the prohibition of non-refoulement in Article 19, and the right to an effective remedy in Article 47. Further to the UK's withdrawal from the EU, the EU treaties no longer apply. The status of Gibraltar is undergoing negotiations on the basis of an arrangement between Spain and the UK reached in December 2020 on border controls that took the shape of an exchange of letters between the representatives of both countries. This agreement seeks to avoid border controls between Spain and Gibraltar for a number of reasons that have to do with the reality of the area, the high volume of regular border movements on a daily basis for work and the provision of services and other purposes that would have made it really impossible and impractical for and not feasible really to keep a proper Schengen control between Spain and Gibraltar. So the purpose of the agreement is to avoid those border controls between Spain and Gibraltar. And the agreement between the two countries proposes to do so by establishing the external Schengen controls within Gibraltar's port and airport, which I have just said that the territory in which Gibraltar's port and airport is subject to an international dispute between two countries. According to the agreement, Spain remains the EU member state responsible for those Schengen controls. But Frontex, the European Border and Coast Guard Agency, would be undertaking those controls on behalf of Spain for an initial period of 4 years that would allow then for a re-evaluation of matters. Now, in September 2021, the EU Council adopted a decision authorizing negotiations between the EU and Gibraltar. And some of these articles and paragraphs in the decision are quite interesting. The decision makes it clear that the envisaged agreement between the EU and the UK should provide that border controls in full compliance with the Schengen acquis are to be carried out by Spain. And such controls would consist of the performance by Spain itself of border checks on entry and exit at newly established border crossing points at the airport, on the port of Gibraltar, on the performance of border surveillance in the adjacent waters. Now, it is obvious that from an EU perspective, if Spain remains the member state responsible, it is Spain that legally takes responsibility for that. And therefore the EU-UK or the EU decision authorizing those negotiations with the UK is really making express reference to Spain undertaking those border checks, but specifically at the port and the airport of Gibraltar, and exercising surveillance in the adjacent waters. But we do know that those are precisely the contentious areas in the dispute between Spain and Gibraltar in relation to, Spain and the UK in relation to Gibraltar. The agreement, according to the paragraph 17 of the decision, provides that Spanish border guards have all necessary powers and obligations to carry out the border controls and surveillance in respect to the refusal, entry, or receipt of request for international protection. And then it comes back to insist that removing those physical barriers between Gibraltar and Spain, including any physical infrastructure and related checks and controls for persons, needs to be done in accordance with certain safeguards, including at least rules that establish that Spain, in cooperation with the UK, would be responsible for the examination of asylum applications submitted in Gibraltar, in line with applicable union law. But we do know that the Refugee Convention does not apply to the territory of Gibraltar. And in fact, the decision makes it clear that supportive measures from the UK authorities do not involve a shared responsibility in examining asylum applications. Now, I need to leave it here, but the colonial status of Gibraltar, the non-self-governing status of Gibraltar, and its disputed international administration between Spain and the UK, in particular in relation to its port, airport, and adjacent waters, raises questions, a lot of questions as how the system is going to work and what the consequences will be in relation to Gibraltar, a territory for which, I repeat, no declaration under Article 40 has ever been made. However, there is a fallback plan, if you like, because the UK did extend the application of the European Convention on Human Rights to Gibraltar in accordance with this treaty's own territorial colonial clause, and therefore the UK would at least be responsible for ECHR violations in Gibraltar in relation to refugees. Now, there is a delay in the negotiations, and therefore we haven't got any actual details of what eventually will happen and how this shared responsibility and how this supporting work that the UK perhaps might be doing will then raise issues of jurisdiction and therefore eventually application issues in relation to Gibraltar. Thank you.
Thank you, Maria Teresa. We start to be aware of the complexity of the different places where asylum of international protection law is applied. Well, we turn now to our third speaker, Professor Martin Den Heijer. He is assistant professor of international law at the Amsterdam Center for International Law, and he is also vice chairman of the Majors Committee and deputy judge at the Court of Utrecht. He has published very recently an article which title is "The Pitfalls of Border Procedures in Common Market Law Review." Thank you very much. The floor is yours, Martin.
Thank you, Sylvia. Let me try to add some Dutch experiences to what has already been said. This is based on a paper I wrote in Dutch 2 years ago after I'd visited the island of Curaçao, and the Kingdom of the Netherlands has 6 overseas territories in the Dutch Caribbean. On the top of your screen, you see a picture of how the Dutch like to see those islands as welcoming tropical holiday destinations, and it's the capital of Curaçao, Willemstad. But if you visit those islands, other perspectives pop up. In the bottom, you see a very large oil refinery, which really dominates the center of the island of Curaçao, around the bay, and which used to belong to Shell, but Shell was so wise to sell it to the local government for 1 guilder, including a clause that said Shell is not liable for any environmental harm. But that is a story for a different paper. The other perspective I want to discuss with you today is the predicament of thousands of Venezuelans who have arrived, especially on the 3 islands very, very close to Venezuela, Curaçao, Aruba, and Bonaire. If you stand on the shore of those islands on a clear day, you can see Venezuela. Their predicament is not well documented. There have been 2 very good reports of the Dutch sections of Amnesty International, afraid only in Dutch, documenting how they are treated and also trying to give estimates about the numbers. Around 20,000 Venezuelans are believed to be on Curaçao, a little bit less on Aruba, and that constitutes 10% of the population of both these islands. And they live there. Well, if you ask me to summarize it, they face indifference. They do not have a status. They live there irregularly. They are afraid of getting into contact with local authorities, afraid for being detained. There are regular expulsion flights from Curaçao to Venezuela. That makes them, of course, very vulnerable. And I should add that these islands are certainly not on the level of development as the European level. The GDP per capita on these islands compares more or less with surrounding countries like Colombia and Mexico. And they face indifference not only from the local authorities. There is very little assistance from NGOs. International organizations are barely active on these islands, and apparently they also face indifference from the government in The Hague. And I asked myself in that paper, why is that so, and what are the dynamics that are going on? And that relates, of course, also to the constitutional setup of the Netherlands. There was a constitutional reform in 2010 after a series of referendums on all the islands, in which the islands were offered 3 choices: full independence, autonomous status within the kingdom, or closely aligned to the European Netherlands. And that followed an earlier referendum in Aruba. Aruba had actually opted for full independence in the 80s, but later the government of Aruba changed its minds. But it did become autonomous in 1986, the so-called status aparte. Curaçao and Sint Maarten said we want the same status as Aruba, a separate country within the kingdom, while the smaller islands, Bonaire, Saba, and Sint Eustatius, said we want to become, well, as closely related to the European Netherlands as possible. And these islands, these smaller islands, are also known as the BES Islands, Bonaire, Eustatius, and Saba. Even though the BES Islands are special municipalities according to Dutch law, legally, there's lots of differentiation going on. For example, there is a separate Aliens Act for the BES Islands, and there is free movement for persons with Dutch nationality between all the parts of the kingdom, but not for persons who have been granted third country nationals, we say them. Some say this on the BES Islands. And in part, this is justified also by all the Dutch overseas territories not being within the scope of EU law by virtue of the EU treaty. Curaçao, Sint Maarten, and Aruba enjoy considerable more autonomy. Each of these islands have their own immigration legislation. A major discussion, constitutional debate, has been going on for a long time within the Netherlands of what the responsibilities are, especially in relation to the assurance of human rights. So the highest law of the Kingdom of the Netherlands is the statute. It ranks higher than the Dutch constitution, which sets out the relationship between the separate countries. It lists the matters of the kingdom, so the common matters. And it says something about who is to ensure human rights. Article 43 of the statute holds that each of the countries on their own are primarily responsible for realizing fundamental rights and good governance. But ultimately, it is up to the kingdom as a whole to guarantee this. And this is also in conformity with the Vienna Convention of the Law of Treaties, which says each state must ensure observance of international law, and internal constitutional arrangements can never be an excuse to not follow international law. This relationship, however, between the kingdom as a whole and the countries has always been very problematic. For a long time, there has been a debate about abysmal conditions in prison facilities on St. Martin, but also on Curaçao. And you see that there is a general reluctance of the highest executive body, the so-called Rijksministerraad, to intervene when things are going horribly wrong in terms of human rights. There is an ultimate power of this Rijksministerraad, which is the Council of Ministers with all the Dutch ministers, including envoys from the islands in the Caribbean. There is a reluctance to intervene for matters of good governance and fundamental rights, also because the islands tend to resist this. They tend to see this as an intervention in local affairs, and readily critique of neo-colonialism is issued whenever the Rijksministerraad tries to intervene. So there have been a couple of these interventions with the Dutch, let's say, taking over some administrative matters, but only in instances of financial maladministration. And human rights have never been considered sufficiently serious to make use of this competence. Also not in relation to the recent influx of Venezuelans. Colonial clauses, Maria-Theresa, you mentioned them. I believe the British, but David may confirm this, were very much in favor of having a colonial clause inside the European Convention. The Netherlands joined the United Kingdom in that respect, but shortly after the Dutch government ratified the European Convention, it did make a declaration that the convention applied to all Dutch overseas territories, including Suriname at the time. It only extended the right of petition, individual petition, later on. Only in the 70s there was an initial fear that large numbers of cases would be brought, but that it is actually still the case that cases from these islands are very, very rare. And it's also because there is not really a strong legal culture on these islands. The Dutch government never made a declaration in that respect under the Refugee Convention, meaning that up to 1986, when Aruba became independent, the Refugee Convention did not apply in Dutch overseas territories. Aruba then decided, well, we do want to become a party, and with the 2010 constitutional arrangements, the BES Islands also became within the scope of the Refugee Convention. But Sint Maarten, and importantly, Curaçao, opted not to become a party. Technically, by the way, these islands are a party to the protocol, not to the convention. And well, in Curaçao, the implications are visible. There was no meaningful or not any asylum procedure at all until a few years ago, in part pressurized by the government in The Hague. There is now an asylum procedure, but that cannot really lead to a status under the Refugee Convention. Curaçao is not a party to the Refugee Convention. It only means that persons can bring a claim in the meaning of Article 3 of the European Convention. However, there are no reception centers on the island of Curaçao. There is no asylum expertise with the authorities. There is no chance of a full resident status, only refraining from expulsion for 2 years, and up to now, 0 claims have been accepted. And well, if one applies for asylum, the routine is that people are put in detention facilities. And the Council of Europe does often bring or sometimes bring visits to the islands, and it is not nice to read the reports of the Council of Europe of what's going on there. It's also visible in the picture on the right, which is of the aliens barracks, which were closed last month on Curaçao. Are Venezuelans refugees, by the way? I do think as some NGOs in the Netherlands are really pushing to make those asylum procedures in accordance, let's say, with European asylum procedures. I do not think that asylum procedures are the solution to the issue on the islands. One sees an exodus. Venezuelans are now the second largest group of forcibly displaced persons in the world, but only a very small minority is recognized in other countries as refugee. Most of the persons that do enjoy some form of legal stay are granted national forms of legal stay, and they come in all sorts of forms and guises, humanitarian visas. Colombia, importantly, has given them some temporary protection status. On your right, you see some data from Eurostat, which shows that the recognition rate of Venezuelans asylum seekers in the European Union is quite high, 95%, but the large majority are Venezuelans in Spain who enjoy, and I hope you can confirm this, Maria Teresa, some national humanitarian visa. They don't enjoy refugee status or subsidiary protection status. So the general trend seems to be to not grant Venezuelans asylum, but of course there is a sense that they are in need of assistance, that they cannot simply be expelled, and therefore there is a trend, and also in the European Union, to refrain from expulsion and to grant them some form of national status. But for all sorts of reasons, the islands in the Dutch Caribbean, Curacao and Aruba, refuse to give them such a status, and therefore the chance that their claim is rejected is very, very high. Of course, self-determination is always individual, and certainly the case that depending on individual circumstances, Venezuelans may be entitled to a status. Let me wrap up. What does this small case study of asylum in the Dutch Caribbean tell us? I think it's very helpful to, if we want to understand what's going on, this situation of official indifference, that it is a colonial legacy. What are, if one looks at the overseas dependent territories, and I think the same is true, David, for UK independent overseas territories, that these are leftovers, the small, less developed territories that are dependent. The bigger ones have become fully independent, so these are the smaller ones that rely on assistance of the European governments. Their GDP in the Dutch territories, at least, per capita is rather low. They are small, they're very, very weak human rights structures. They're simply not able to fully realize the human rights that the European governments have signed up to. They need assistance in that respect. What struck me was that self-determination and human rights are not in a harmonious relationship. Self-determination is used as an argument by the government in The Hague to not intervene, to not give assistance, and indeed it's used as a shield by the islands to say, we don't want your interference and we want to do things our own way. As one sees that these colonial clauses and modern human rights treaties do not have them anymore. But the effects of the other ones, as found in the Refugee Convention, and also the fact that EU law simply does not apply in overseas territories, means that standards of protection are lower, that there is less supervision, less monitoring, and less incentives to change things. So I'm afraid my story about asylum in the Dutch Caribbean is not very, very positive, and I'm hoping that in the UK things are a little bit better. Sylvia, back to you.
Thank you very much. Even if your PO is such disappointing. Let's go to our last panelist. We turn now to our last but not least speaker, the director of the Refugee Law Initiative and the soul of this conference, Professor David Cantor. You have the floor.
Well, many thanks indeed. The title of my paper for this panel is Quaint and Marginal ? Refugee Law, Sovereignty and British Non-Independent Territories. But I'd like to begin by thanking Maria Teresa and Thomas and Martin for allowing me to join their panel on this fascinating topic. Refugee law in non-independent territories may look like a quaint and marginal topic, especially for a major former colonial power such as Britain. Indeed, British non-independent territories such as Ascension Island nowadays appear in refugee news, mostly as far-flung places where the British government regularly threatens to dump its asylum seekers for processing, before, of course, finally plumping instead for Rwanda earlier this year. But I'd like to make the case that for the refugee law field, these tiny and hard-to-research non-sovereign territories have the capacity to shed light on certain important legal debates. To complement other papers on the panel, I'll advance this contention by reference to the non-independent territories for which the UK is responsible. In fact, the UK offers an important case study for refugee law in non-independent territories. Empire had already had its heyday at the start of the 1950s, when the Refugee Convention was adopted. But even so, the UK still retained responsibility for over 70 non-independent territories at that time. As such, the approach towards refugee law in the transition towards independence by many of those former colonial territories has crucial historical significance for our field. But that, I'm afraid, is a paper for another day. Yet, even in today's largely post-colonial world, the UK has an outsized role in this regard. Of the 17 non-independent territories that remain on the agenda of the UN Special Committee on Decolonisation, almost 2/3 of them, 10 in total, are territories for which the UK is responsible. But that figure does not give a full contemporary account of British non-independent territories, which actually number 17 at present, and you can see them on the screen now. Thanks a lot, Susie. Alongside the United Kingdom, which of course comprises still, although perhaps not for much longer, England, Scotland, Wales, and Northern Ireland, the undivided realm of the UK also includes not only the 3 Crown dependencies of Jersey, Guernsey, and the Isle of Man, which are of course close neighbours to the UK, and you can see them there in blue, but also 14 further British overseas territories spread out across the world. These 17 British non-independent territories are mostly small or tiny islands, although of course the massive British Antarctic territory is an exception. Whilst some have no permanent population, others have populations ranging from 50 people to tens of thousands of inhabitants. For the purposes of refugee law analysis, 2 further preliminary observations should be made. Firstly, whilst each of these British non-independent territories has a constitutional relationship with the UK as the sovereign power, none is actually constitutionally a part of the UK itself. Rather, each is a separate constitutional unit and legal jurisdiction with its own distinct constitution and laws. Thus, for example, whilst UK law makes provision for the citizenship of people connected with the territories, each territory has its own immigration laws. This will be important to appreciate as we go on to discuss the existence of refugee law in these territories. Secondly, it must be admitted that these British non-independent territories are pretty marginal in terms of the number of refugee arrivals. Indeed, over the past decade, most have received no more than a handful of asylum applications each year. For example, the Bailiwick of Jersey, an island close to the UK and the territory with the largest population, usually has between 0 and 2 claims for asylum per year. Certainly, although many of these territories serve as sometimes accidental transit points for refugees, their small size and population and their often out-of-the-way location mean that they are usually not destination countries for refugees. Despite these features, since ratifying the Refugee Convention and Protocol, the sovereign state of the UK has, at different points in time, extended the 2 treaties to 7 of its 17 non-independent territories through the application of Article 40 of the Convention and Article 7.4 of the Protocol, as Maria Teresa explained. The UK applies the same reservations and declarations to these extensions as apply to the UK. That extension has taken place to only 7 of these territories, reflects the practice that these territories must be consulted by the UK before it applies a treaty to them. Under international law then, in those 7 territories, the refugee law obligations of the UK are identical to those in its own territory. Given the existence of identical international obligations towards these refugee law treaties, what may seem surprising is that the UK has not extended its own national refugee law frameworks to these 7 territories. We might expect that the UK government would be concerned to ensure that its treaty obligations are respected to the same standard and in conformity with those rules on its own territory. However, it is a settled principle that British asylum law does not apply automatically in any of the 7 territories. Rather, it's up to the government of each separate territory to decide whether to pass legislation on refugees and what form it should take. This leads to quite some diversity in local legislative practices in these 7 territories. Thus, the Isle of Man has not passed any refugee laws, but rather uses discretion to admit those who look like refugees, or does so in agreement with the UK. By contrast, the other 2 Crown dependencies of Jersey and Guernsey have adopted refugee laws, but whilst those in Jersey largely incorporate UK refugee laws, this is less evidently the case for the broader refugee rules that exist in Guernsey. At the same time, each of the 4 British overseas territories to which the Refugee Convention has been extended have also adopted local refugee laws, but they are equally diverse in their provisions. This, of course, is not to say that any of the refugee law provisions or practices contravenes the UK's treaty obligations. However, whilst family resemblances exist, they're clearly not identical either to the UK domestic refugee law either. What, though, of the remaining 10 non-independent territories for which the UK is responsible, but to which it has extended neither the Refugee Convention nor the Protocol of 1967? Given that neither refugee treaty applies to these 10 territories, we might naturally expect none of these British overseas territories to have adopted refugee laws. But here again, assumptions cannot be made. In fact, 4 of these non-independent territories have their own refugee laws, and another one appears to be discussing adoption of a refugee law as we speak. Moreover, of the 5 remaining territories that do not have refugee laws, it's worth noting that 2 have no permanent civilian population residing there at all. Among those 4 territories that have not had the convention extended to them, but which have passed their own legislation on refugees, here too, the extent and flavour of the rules on refugees is highly variable. They range from an extensive and EU-influenced set of asylum laws in Gibraltar to the single legal provision governing asylum seekers and refugees in the South Georgia and South Sandwich Islands. The content of the rules varies accordingly too. But the key point that I would like you all to take away from this very brief description is the good proportion of the non-independent British territories to which the Convention and Protocol have not been extended by the UK have, in practice, exercised their local legislative powers to create refugee law rules broadly similar to those in the UK or other states bound by refugee law treaties. So by way of conclusion, what does all of this add to our understanding of refugee law more generally? I think that there are 2 main takeaways that deserve further comment and investigation. The first point is that it underlines the diversity of refugee law as a field. I've argued elsewhere that if we truly want to understand what refugee law is, then we cannot confine our investigation to international instruments alone, or treat national refugee law as a mere window onto the interpretation of international treaties. The sources of refugee law are more varied than that, as the example of the British non-independent territories shows. Firstly, even those to which the Convention has been extended by the UK do not simply replicate the national refugee law provisions adopted by the sovereign state. And secondly, many of those which are not bound by the treaty still develop rules in line with its provisions. This, of course, adds to the growing body of evidence on the fundamental nature of the rules of refugee protection. the practice canvassed here adds to this body of research by showing that it's not only non-signatory states, such as the former British Protectorate of Qatar, for example, that have adopted refugee laws, but also many non-independent territories for which the UK still remains responsible today in our post-colonial or post-sovereign world. More pragmatically, these findings suggest also that laws on refugees are not merely nice to have, but are rather seen as practically useful by governments in dealing with a world in which refugee movements are an inescapable reality. My second point, though, is that the practice of British non-independent territories points to the possibility that actors other than states may be capable of offering asylum. This is in some ways a disconcerting and unsettling proposition, since in the field of refugee law, we're used to thinking of asylum as a prerogative exercised by sovereigns alone. However, the evidence that refugee law can be legitimately created and implemented by British non-independent territories, even those to which convention obligations have not been extended, shows clearly the limits of this thinking. In turn, it requires us to reconsider certain assumptions of our field. Can such territories provide asylum as a matter of international law? If so, then on what basis? Is it sovereignty or some other basis? And could perhaps other kinds of non-state actors with strong territorial links perhaps equally do so? Many thanks.
Okay, thank you. Thank you very much to all of our panelists. Very interesting contributions. We can now open the discussion with at least one question that we have from the chat, that is from Hugo Story, who intervened, I think, in the first day of the conference. He says, fascinating presentations. There is a mixed picture in regard to 1951 Convention and Human Rights Convention obligations having application. Does the panel think that even in the cases where no such obligations extend, the customary international law principle of non-refoulement can require consideration both in asylum and non-ill treatment aspects? Can this principle carry the necessary weight? Who wants to intervene? Who wants to try to respond to the question?
I can say something about it if no one else volunteers. It's a very good question. But to an extent, I do think that the question is moot, but I'm also looking at Thomas and David to see how this is in Denmark and United Kingdom. I do believe that the UN human rights treaties, the ICCPR, the Convention Against Torture, do not have any colonial clauses, and that the UK, Denmark, and the Netherlands are party to those UN treaties as well. As I said, the Netherlands has declared the European Convention to be applicable to all overseas territories, so it is not necessary to go to customary international law. And what I see as the key problem, well, the lack of appropriate oversight, supervision of UNHCR is a problem on the islands, but the bigger underlying problem is simply a lack of a human rights culture, including no NGOs, no lawyers with specific expertise. So even though these countries are bound to UN human rights treaties and the European Convention, there's simply insufficient familiarity to bring cases. And that is the key problem, to organize knowledge of the law and to make use of it. But I'm keen to hear how this is in other European countries.
Professor Thomas Hamilton Hansen, you have the floor. Thank you. You can respond.
Many thanks, and thanks for a very interesting question, and also thanks to my other panelists. I mean, I can very quickly say that in regard to Greenland and Svalbard, the situation is as follows. Denmark sort of specifically considered the issue of exemptions to the Refugee Convention, but was, of course, also as one of the lead drafters, very concerned not to set a negative principle. So while there are colonial clauses applying to some human rights instrument, it's not the case for the Refugee Convention and nor for the European Convention of Human Rights. So the situation there is a little bit the inverse of what some of the other panelists are talking about. We have international law. What's lacking is a sort of a national legal framework giving effects to refugee rights. Now, as regards SWLBIT, the situation is more tricky. And I think there would be an argument to that effect. I even called the sort of local head authority in SWLBIT because I was kind of pondering about this very issue and to what extent they consider non-refoulement cases when expelling foreigners, which he has the competence to do, if they do not have the means to care for themselves. And again, sort of echoing David's point about very, very small societies. I mean, we're talking about here about the supreme authority on SWLBIT, but he also runs a gas station on a day-to-day basis. And no, he did not have any of those concerns, but he made the very straightforward point that any expulsion from SWLBIT would de facto go via Norway. Yeah, I mean, the flight routes go to Norway, meaning that you would have a carryover to Norway in those situations. So if not at SWLBIT in practical terms, the non-refoulement obligations would hit immediately upon arrival in Norway. And unless you sort of imagine quite theoretical situations where there might be a kind of threat in Norway, that's probably not the case. But I also wanted to point on to Maria Teresa. I mean, you had some points regarding also, as I remember, some of the former Australian colonies and sort of like takeover situations upon independence that might be relevant in regard to Hugo's question here.
Yes, we do have some examples of former colonial territories that have later acquired independence, and I did look into that, as Thomas, you're right, in relation to the application of the of Article 40. So linking it to Hugo's question, which I think it is about whether the customary international law rule of non-refoulement can actually lead to considerations of asylum. I have made that claim before. I've argued that there is an asylum obligation that derives from non-refoulement, and I have read Grant Mattson and Paul Weiss's work in relation to that, or having at least a suggestion that that might be the case. But the last part of Hugo's question is, if it exists, can it carry the necessary weight? So I think that that's an issue of enforcement, and we have seen that it's very difficult. Where do you enforce individuals? Where do they enforce a rule of international law if that rule has not been incorporated domestically? So the only avenue for that would be for states to take other states before the International Court of Justice, which I doubt will happen. So in terms of the lack of enforcement of the rule, leads to some questions, but you will never know what kind of circumstances might actually lead to one of those cases where a big question arises and states do actually feel that they have something to say. I mean, who would have thought that the European Union would adopt a temporary protection directive in relation to Ukrainian refugees, when for the last 20 years we have seen so many instances in which it has refused to do so. So you never know what kind of political and other kind of issues might actually make a legal question more relevant.
David, go ahead. Thank you.
Thanks. Hugo, I'm going to tackle your question from a slightly different angle, and many thanks indeed for putting it there. I'm certainly not an expert on the status of non-independent territories under international law. I suspect my other panelists would be better placed to say that. But your question implies an anterior question, which is, are these territories bound by rules of customary international law? And that might well depend on the rule in question. Yeah, I mean, some rules might bind non-state entities. You could think about rules of non-international armed conflicts, for example, which, if a non-international armed conflict erupted in one of these territories, then the fact that it happens to be a non-sovereign territory would make no difference, I think, to the application. But there may be other rules which require some element of sovereignty. And so I suppose, the question is, does the principle of non-refoulement extend beyond states to bind other actors? And I think, many commentators would like to say yes in answer to that question, but it's certainly something that somebody who's, written on the customary nature of the non-refoulement principle, like Maria Teresa, would be better placed than I to answer. The second question that I think is sort of implicit there is, where you have these non-independent territories which are developing their own refugee laws, is it out of a sense of obligation? And if it is out of a sense of obligation, where does that obligation come from? Because the obligation is not one that's derived from treaty, because the treaty hasn't been extended to their territory. So what I would like to do in developing this research is actually try and pick apart a little bit more why territories which have developed their own refugee legislation, despite not being, not having the convention extended to them by the sovereign realm of the UK, do that. Is it purely as a matter of utility, or is there a sense of obligation there? Because I think that those sorts of questions become important, especially if we start to see these entities as perhaps having some kind of weight, not much perhaps, but perhaps some kind of weight in the creation of custom or the development of it. Thank you very much. I don't know, Maria Teresa, if you want to say more about non-refoulement asylum.
Okay, thank you. We have already, I think, 5 minutes to continue with our discussion, and I will take advantage of my position as chair in order to say a comment and I think a question also. Before starting this session, I had the impression that we were talking, we were going to talk about the idea that in some places sovereignty is more or less hard, and in some other places, like at the borders, like in Spain, since the NDNC case, or in non-autonomous territories, this sovereignty is like diminished or not so hard. But after the hearing from you, I have the impression that this is not like this, or not so simple, because we can find areas where even if sovereignty is more or less diminished, but it's not so difficult to accede to rights. But in other areas, it's so difficult to accede to rights. So it's not only a question of access to rights, but or difficulties to accede to rights, but a question of diversity and complexity, because we cannot find a territory that is the same as one other territory in your exposition, in your talks. Do you have any idea on this, if this can raise problems of discrimination at the end, or problems related to more benefits of people that accede to some territories and not to the metropolis? I don't know. You have any idea? I think some. Thomas has raised something in the chat. You can you want to okay, go ahead.
All right, yeah, this was just a quick remark to David's question, and for any participants interested in that issue. Thanks very much for this other question. I mean, the cases I've been looking at are obviously a sort of more mixed bag, yeah, because you do have more liberal rules of entry. That applies both to the Greenland case, as I explained, but certainly also to the Svolbard case, which is even more peculiar, as Svolbard is subject to an international treaty from 1920, the Spitsbergen Treaty, which formally limits Norway's possibilities to perform migration control. What emerges, however, is a set of, I think, quite principled issues that sort of relate to the sort of transfer type of situation. What happens if Danish authorities carry out an asylum procedure and transfers a person to Greenland? Does the doctrine of acquired rights apply in this type of situation? I mean, knowing that these are people that doing their asylum procedure and up until the point of being recognized as refugees were present in the mainland Danish territory and then are transferred to a territory within the same sovereign sphere, but which doesn't provide for even the sort of most basic refugee rights, at least on the sort of social economic side. And I was interested in this also because I tried to kind of search out more general human rights case law concerning Greenland. And I must say, I kind of echo Martin's point in this regard, in the sense that there is surprisingly little there. You would have imagined that there would be some kind of jurisprudence to lean up against concerning the generalized differential treatment in socioeconomic terms. I mean, this surely raises issues for other people than refugees. But there is surprisingly little, and maybe because of lack of litigation, but I also have a sense when I'm looking at what's coming up in committees and trying to find references to Greenland, that there indeed Svolbit, that it's sort of an issue that is somewhat sidestepped by at least some human rights institution as well. And it may come back to what Martin also highlighted, this sort of seeming tension between self-determination and human rights claims, which of course a tension we find elsewhere. Yeah, if you look at, we used to work in Sweden, if you look at Swedish self-government rules for municipalities and regions, I mean, we also have a string of cases before the different human rights committees where Sweden defends itself by saying, well, you know, we can't actually impose these sort of demands on municipalities and regions because they have the power. And of course, from the committee side, well, we treat the state as a kind of as a single organ in this regard. So there are some tensions there that I think speaks to this sort of inversion of externalization problem, and that across issues, also beyond the cases we've dealt with here, could merit more insights. And then I must say, I also, just as a final remark, I kind of would like to echo some of David's remarks in the sense that I wondered myself if I would be able to justify spending so much time and writing an article for a case that involves a single refugee, as in the Greenland case. But I do think there is a point to systematically approaching this type of outliers in a manner that helps disclose systemic insights, whether it's the legacy of colonial mechanisms and refugee law, as Maria Teresa pointed to, these sort of tensions in international law that Martin pointed to, or a kind of methodological internationalism, which is sort of a point I took from David's presentation.
Okay, thank you very much, Thomas. Martin, Maria Teresa, David, you want to take the floor for these last 2 minutes that we have? Maria Teresa, you have the floor. Thank you.
Just a very quick remark to say that when I first started looking at the colonial clause 10 years ago, that was really a non-issue. It was an issue of refugee law history that had to do, and I borrow the words of Martin's, that we're talking about leftovers. So these are remains of a different time and different territorial relations between sovereigns and territorial entities in different places, but it had very little practical application. But things have changed. At the time, 10 years ago, the only sort of instance in relation to such territory was the very specific case of the Chagos Islanders and the military base, the US military base in Diego Garcia, in the context of the US war on terror. So issues of non-refoulement arising from issues of the CIA flights and so on. So that was quite remote. And the island of Nauru, that was a former territory, colonial territory of Australia, but since then it had acquired independence, and it has eventually become a party to the Refugee Convention. However, what I think is interesting is to see that in the last few years, this has become a relevant issue again. Venezuelan refugees is one of the issues. The issue of Gibraltar might eventually become an issue because around the same territory that surrounds Gibraltar, but the Spanish territories are a point of destination increasing arrivals. So why not in Gibraltar itself, if Spain is going to be the member state responsible? So there may be issues coming up, and of course the UK agreement with Rwanda, which is a state, but again, it's a former colonial territory of Belgium. So there are a lot of issues that I think are coming up that do require an understanding of the legal matters.
Okay, perfect. Thank you. Thank you very much to all of you. I guess it's time to close this stimulating session.